What is a mediation in a personal injury case? So you may have been in a car accident or had some other type of injury, and you've hired a lawyer and it's in litigation. It gets to the point where there is a mediation and you're probably wondering, what does that mean? Hopefully your lawyer explained this to you, but I'm going to go through it also. So my name is John Howell. I'm an injury attorney in California, and I've done many mediations. I've been through the process many times, and I'm going to go through a couple things that you should be aware of for a mediation. Mediation, sometimes you may also hear mandatory settlement conference, and that's a little bit different, but many cases go to mediation, and that's because the court and the judge wants the case to settle, and they want it to settle informally without a trial. Trials can be slow, they're expensive, and even if you go through a trial, it doesn't mean the case is resolved. Even if you get a verdict in your favor, you could end up with this verdict, which is just a piece of paper, and the other side could appeal it, or you're going to have trouble trying to collect. It's like collecting judgment from somebody. You can imagine how difficult it is for businesses to collect unpaid bills. And it's the same idea. So oftentimes people are encouraged to go to mediation to try to settle a case. In the mediation, particularly now, post pandemic in California, many of my mediations are done on Zoom, where me and my client are in a Zoom room. Then there's a mediator, which I'll explain who that is in a little bit. And then they go back and forth with the defendant or defendants who are all in their own separate rooms. The mediator is often a retired judge or an attorney that does mediations as part of their practice. And some people have a whole business, all they do is mediate cases, and some are very successful and they're very effective at it. The mediator is not really there to pick one side or the other, they're a neutral. And what they try to do is facilitate communication and push sides to reach a compromise. There's an old saying about mediation that the mediation is effective if both sides walk away upset, but the case is settled. Because if one side is more happy than the other, then maybe the mediator didn't do their job in trying to reach a fair compromise. But I'll be honest, there's many times where I've reached a compromise that I was happy with in a mediation, and I'm sure the other side was happy with too, because they got the case resolved and it's off their books. So during the mediation, it's not like a deposition. So often my client will be there, but there isn't a court reporter. You're not under oath. And in fact, a lot of times mediations, there's a mediation confidentiality. So whatever's discussed in the mediation is confidential. Before the mediation, many times, more like almost 99% of the time, I'm going to submit a document called a mediation brief to the mediator explaining our position of the case, maybe arguing why the defense's position is wrong or inaccurate. I'm going to provide evidence and basically set up the mediator to have as much information and be in my favor as much as possible. Because part of what I'm trying to do is, even though the mediator is neutral, I want the mediator to be an advocate, or at least really understand my side and understand that if it doesn't settle, what am I going to be able to achieve if it goes to trial? And I often share my mediation brief with the defense because I want them to know how strong our position is and what arguments we're going to make. I know some people don't like to do that, but I have found that if you tell the defense and you're not scared, and here's our evidence, and this is what's going to happen if you don't settle the case, you can get a good result. But if you hide things, it makes it look like maybe you're scared about your case, or you're scared about what's going to happen at trial. And I know a lot of times the defense don't always share their brief. Of course, there are times where maybe I know something about the case that I don't want to make public or known to the defense. But more often than not, I'm going to be sharing things because I'm going to share the strongest parts of my case. So once the mediation begins, it can take many hours. Sometimes it takes multiple days. Typically, the shortest mediation is like 3 hours, 2 to 3 hours. Oftentimes, you'll see 4 hours for a half day on a smaller case or a case where the issues aren't as complex. And there's a lot of downtime. So the mediator will come in, they'll talk to my side, they'll talk to me. They may talk briefly to my client and talk to my client just to get their feelings or perspective on the case. And then they'll go and talk to the other side. And if there's multiple parties, they'll talk to all the parties. And there could be hours sometimes, or a long period of time where you're waiting because the mediator is talking to everybody and maybe taking notes. Eventually, they circle back around and they tell you what the other side is saying, some arguments, maybe give the attorney like myself an opportunity to respond to some of those arguments. And then usually, because it's all my cases are civil cases and it's about money, we start talking about money. And before the mediation, I try to have a demand ready to go and what we're looking to settle the case for. And we discuss with the mediator what our next offer is going to be or what the offers are from the defense and what our next demand is going to be. And there are many different techniques for negotiating in a mediation, but at the end of the day, it's like a negotiation where maybe they offer something and then you reduce your demand a little bit. Or sometimes you can suggest a range that you're looking for. Or sometimes the mediator may even suggest a number that they think could get the case resolved. Not necessarily what they think the value of the case is, but if they think the case can get resolved, they may try to kind of suggest a range or a number to you. Sometimes the mediator is going to talk to the attorney by themselves away from the client. Oftentimes that's done because the mediator is going to be sharing information that could upset the client or make them emotional. And I have seen in these mediations where the mediator says things and then my client maybe is suffering from a really bad injury or is very emotional, and then it just shuts the mediation down, and now my client can't communicate with me or is too emotional or needs to take a break. And oftentimes the mediator will tell me those things privately and then have me share that with my client because I have a rapport with my client and I can talk to them about some of the more emotional or difficult parts of the case. And I know how to phrase it or talk to them in a way that it doesn't make them break down emotionally. After going back and forth, and it can be frustrating, particularly with some insurance companies or some adjusters, they view mediation as a way to grind down the plaintiff. They view it as a way to make it as tedious as possible. Sometimes they'll make a lot of very small moves over and over and over again. That's just a mediation technique. And, I see it all the time, and we just respond the way that was most appropriate. And then sometimes the case can get settled or sometimes it'll get stalled out and the mediator will say, okay, I don't think we're getting anywhere. Or sometimes the mediator will suggest a solution to try to get the case resolved. And then sometimes if it doesn't settle, even though it doesn't settle, we learn things about the case. We learn some potential arguments that the defense has and whether we need to maybe interview a witness or subpoena a witness or get some certain medical records or do some more investigation so that we can understand the case better. Or maybe the defense needs to do that in order to understand the case better. Or maybe there are things like my client needs some additional treatment or needs to see a specialist about a certain issue. And so even though the case doesn't settle at mediation, I would say many times after the mediation, because of the discussions we had in the mediation, we are able to eventually get to a settlement. And it could take months or weeks later, but it can help. And then, of course, if it doesn't settle and we're just stuck and both sides don't see any possible resolution of this case or don't see eye to eye on any of the issues, then it goes to trial. And like I said, in a trial, you are going in front of 12 totally random people and they come with their own life experiences, biases, prejudices, like everybody, like myself. And then they're going to make a decision. Then you get a verdict and then you get a judgment and then you have to collect on that judgment. And sometimes they'll appeal the case and that can go on for a very long time. I'm sure you hear in the news about trials and verdicts and appeals that have been going on for years. And that is one of the benefits of just going to the mediation and trying to resolve the case and putting your best effort in trying to get it resolved. So those are a couple things about mediation and why they're important in cases, particularly injury cases.